I have a question. Are you a judge? You don't have any jurisdiction over me. I would argue you don't have any jurisdiction, okay? No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir.
Today's courtroom hearing is definitely one you won't forget. It features a virtual court appearance where a defendant raises a series of sovereign citizen-style arguments after being cited for allegedly running a red light. As the hearing unfolds, the responding officer appears to testify about what happened, making the case far more challenging for the defendant. Instead of focusing on the facts of the traffic stop, the defendant spends much of the hearing presenting unusual legal theories that the judge has clearly heard before. The exchange quickly becomes one of the most memorable parts of the proceeding as the judge calmly addresses each claim and keeps the hearing on track. It's an interesting courtroom exchange from start to finish, and there are plenty of moments that will probably leave you shaking your head. What do you think about this hearing? Let me know your thoughts in the comments below. And if you enjoy courtroom breakdowns and legal commentary like this, don't forget to leave a like and subscribe. Now, let's jump into the hearing and see how it all unfolds.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
Very well, Mr. Mathis. Today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year, at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color, on 11 Mile Road, near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility, and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
Do you solemnly swear the testimony you shall give before this court shall be the truth, so help you God?
I do.
Thank you very much. Please proceed.
Before we hear the
Magistrate, on May 24, 2024, approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I
doesn't allow the conversation to get sidetracked by arguments that don't relate to the legal issues before the court.
with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow
and moves
to turn.
the hearing forward without letting
that vehicle
it become
then
an
proceeded
argument.
through the light.
In my opinion,
as I
that's
looked
one of the
up
most
at the
effective ways
traffic
to
light,
manage
that
a
light was red
situation
for
like
that
this.
driver.
With
The
respect
judge's steady approach
to your
really stands out
selection
because he
of
maintains
citation,
control of the
you
courtroom while
elected to
remaining
simply
professional
issue a
throughout the
ticket for
exchange.
impeding traffic. Is that correct?
It's interesting to
did,
watch how he
Magistrate, at that
handles
That's
time,
based
each
on
interruption without
your
losing his
discretion, your
composure.
training, and your experience.
What do you think
It
of the
is.
judge's
Thank
approach
you.
so far?
You obviously have the right to
Do you
rebuttal
like
if you
the way
choose
he's
to use
handling the
it.
hearing, or would you have
Officer
done
Moran.
something differently?
Mr. Mathis, it is now your
Let me know
turn.
your
What would you like
thoughts
the
in the
court to know,
comments.
sir?
So,
With that
I have a
said,
question.
let's get back
Are
to the
you a
hearing and
judge?
hear what the officer has to say.
Mr.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge black in color with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
With respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that
And
time.
that's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So, I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please.
The defendant keeps insisting that the court doesn't have authority over him, and that immediately raises an obvious question: if he truly believes that, why appear for the hearing in the first place? It's a claim that comes up fairly often in cases involving sovereign citizen-style arguments, but the court proceeds based on the law governing the case, not on whether a party agrees with the court's authority. When it comes to traffic cases, courts generally have jurisdiction as provided by the applicable state laws, so simply declaring otherwise isn't enough to end the proceedings. That's why these arguments rarely change the direction of the hearing. I've noticed that hearings involving these kinds of claims seem to be showing up online more and more. Whether that's because they're becoming more common or simply receiving more attention on social media, it's interesting how frequently they appear. As for this defendant, it's difficult to know what he genuinely believes or what strategy he's trying to pursue. From the outside, though, the approach doesn't seem to be helping his case. What do you think? Do you believe he actually expects these arguments to work, or is there something else going on? Let me know your thoughts in the comments. Now, let's get back to the hearing and see what happens next.
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in
Right
terms
now.
of who's present on behalf of the city of Royal Oak?
Where is the city of Royal Oak? Please bring the
Court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So, what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code
as I
of the
was
city of
traveling,
Royal Oak as it is adopted.
as I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Michigan law clearly states that traffic violations like running a red light are considered offenses against public safety, not individual people, so no, you don't need someone who got hurt to make this case valid. The state X's the plaintiff in these situations because running a red light puts everyone on the road at risk, and that's enough to land you in court. Honestly, I don't know where this guy got that information. Maybe it was Google or something, but let's get back to.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward. As far as the injured party, no one was injured. You guys are
Mr.
trying to
Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge
This is
me?
a civil case
Why are you
under
trying
the
to
Motor
charge
Vehicle
me?
Code as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any injured party,
Very
no
well.
one was injured. You guys are
Officer
trying to
Moran, any rebuttal testimony?
No rebuttal testimony.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district, and at that time, the city of Royal Oak would be represented by a city prosecutor.
So, what do you think about the outcome of this case? Do you think the $175 fine was an appropriate penalty, or would you have handled it differently? Personally, I think the hearing sends an important message because the judge stayed focused on the law from beginning to end and didn't allow the proceedings to be sidetracked by arguments the court didn't find persuasive. In Michigan, many routine traffic violations, including allegations such as running a red light, are generally handled as civil infractions rather than criminal offenses. The purpose of those penalties is to encourage compliance with traffic laws and help protect public safety on the road. One thing I especially noticed was the judge's professionalism. Even when the defendant repeatedly raised arguments that the court rejected, the judge remained patient, explained the applicable law, and kept the hearing moving without letting the exchange become personal. That level of composure isn't always easy to maintain. At the same time, the defendant's interruptions in courtroom behavior definitely made the hearing more difficult. Judges have the authority in certain circumstances to address disruptive conduct, including through contempt proceedings when legally appropriate, but whether to take that step depends on the specific facts and the judge's discretion. In this case, the judge chose to resolve the traffic matter and move forward. What stood out most to me was how confident the defendant seemed in the arguments he was making, even though the court consistently rejected them. Whether he genuinely believed those legal theories or simply thought they would help his case is impossible to know from the hearing alone. Now I'd like to hear your opinion. Was the judge's decision the right one, or do you think a stronger response would have been justified? Share your thoughts in the comments below. If you enjoyed this courtroom breakdown, don't forget to leave a like and subscribe for more videos like this.